We're going to start the 19th meeting of the Civilian Review Board. A huge thank you to members of the board. We had some heavy lifting this month with, the 2 meetings, and then not only 2 meetings in February, but then our regular meeting is next week. So lots of work. So I do want to thank you for your cooperation. The first order of business is approval of the minutes from the previous meeting. Is there a motion?
Second.
And a second. All in favor, please raise your hands. Approved. IG, you're up.
Well, I don't think you did you want me to talk about the,
It's your update,
oh, my update, okay. So,
but also to share your suggested procedures that I have approved with the board. So if those have not been disseminated, please do that.
okay, I believe, are they up under? Okay, okay. So just briefly, if you look at the attachment, these were just some suggestions that I was making for the Civilian Review Board regarding some of the procedures involving, one would be review and report. So I'm just not going to go word for word, but I'll just briefly.
Actually, Inspector General Hendricks, I would just like the board members to take these with them. From my perspective, they have been approved. Let's just utilize them the next time you review cases. And if you have any concerns, let's table them for the March meeting, because I do want us to move along with this meeting. These were developed between Inspector General Hendricks and Ms. Ross. And so, again, constant improvement in processes and procedures. These are her suggestions. I think they're good. Not to say that we aren't going to incorporate some other changes, but today, just take them, maybe review them in your next committee meetings, and then go from there, okay?
And just one other brief update I wanted to give the board, and this was just based on a conversation that was at the last meeting. So I did reach out to Tierra talked, and I did reach out to IB. So going forward, when it comes to our investigations where we find additional findings, we will be doing those additional allegations through the Department of Inspector General. So it will say that the Department of Inspector General has an allegation, and then we will sustain that, and that will be an addendum that we'll be putting on the report. That's what previously IAB was doing. So going forward, you will start seeing that with some of the new reports.
You also met with Chief Bryant. I recall at the last meeting, one of the board members wanted to know, what's the process when we send over the packets, and I think we've now sent 2 of those. Could you please share, I believe you had a conversation with the chief, could you please share with the board what you were told? I subsequently had a conversation with the chief, but.
So what we will be doing is, I meet monthly with the chief, so we will be meeting again in March. And part of that is me meeting with her team, because we had already talked about the process. Once the reports come over there, I wanted to do some follow-ups on any recommendations that we've made for disciplinary, how that's going to look. So I will be meeting with her in March.
Excuse me, that's not what I'm referring to. When the cases go over, there's a process that she utilizes in-house. And so, and maybe it's Mr. Blunt who could tell more, and I don't want to say down the chain, up the chain, but they are reviewed by members of her team before they really get to her in terms of making a decision. Am I correct on that?
Well, I know based on the conversation I had with her that they're still trying to work those out, and that was the reason why we were going to have a meeting, so we'll be able to see exactly what that process is going to look like.
I'm pretty sure from what she told me, and I don't know if this is governed, again, by the contract or whatever, but the complaint has to go up the chain of command. So that is still happening, even though it is coming from us. So it's not that they just go over to her office and she reads them and signs off. No. There's a process in the chain of command where they are looking at them. And then I agree, you're going to meet in terms of further steps between the IG's office and the chief. But that's the best answer I can give you at this point.
If I might ask just a clarifying question, I'm not sure IG will be able to answer this or can find out. I think the concern that some of us had last time was how we learn of the disposition of these. Is there going to be a monthly report or some way for us to get feedback to the board that, we
Pastor,
made these
That's
recommendations?
what hasn't been determined. I mean,
Oh,
so she
okay.
doesn't have cases back to her yet.
Oh, no, I get that. I just, so,
So this meeting that they're going to have, that's one of the points that they will be discussing.
okay.
Right.
You know, how do you report back to the board? That has not been determined at this point.
Okay.
And actually, I am going to attend that meeting. It's the monthly meeting between, the IG and her team and the chief, but I will be at that meeting also.
Yeah.
And do you want to talk about
Yes.
community engagement?
Yes, and I did want to make an announcement that the town hall meeting that we had scheduled, that is going to be postponed. There's some additional work and preparation that needs to be done. And so once we are able to work on that, I'm sure with Jarrell and Ms. Younger, they'll be able to notify the board when we have that additional update to go forward.
It has come to my attention that really there's been a disconnect between the board and Ms. Younger's committee and your office. I spoke with Ms. Younger yesterday, I guess. What I want is there to be a meeting of Ms. Younger's committee with you and Mr. Black in attendance. I don't know if you want your consultant there. And I also plan on being there. So this will have to be a public meeting, with notice, but it would be for your committee anyway. Because quite frankly, I think we have a number of matters that we need to discuss, including the topics of these town hall meetings. We have not really been involved, and I think that we should be. So I don't know, I'll task Ms. Younger with getting the meeting scheduled. Okay, thank you. I'm sorry, Pastor Dathan, did you have something else?
It sounds like it's just completely opened up, so that's fine. In terms of like how we're organizing these, I was confused about the topic as well at First Church, because I think it was advertised as like a police.
It was incorrectly advertised. I was quite concerned when I saw
Yeah.
the topic.
Yeah,
Yes.
We were trying to, determine even what the role of the IG and the board was in the way that it had been
Right.
advertised, so.
We were definitely outside of our lane
Okay.
in terms of that topic. Okay. Is there anything else?
No, I think we're done with that update.
Okay, thank you. Before we get to City Work Rule 8, the chair wants to make an appointment. At the last meeting, Board Member Fluharty mentioned that Rules and Regulations needed another member, suggested Member Strickland, and I am appointing Mr. Strickland to that committee. Any questions or concerns?
Thank you.
And just another bit of business for the record, and so that it is clear. I appoint individuals to committees and I remove them. So I want to officially remove Mr. Aragon from the review team. That's all I need to say. City Work Rule 8.
Susan? Okay. All right, so at the last meeting, Chair Jackson asked that Rob and I get together
and put some information before you with regard to how Central Work Rule 8 should be interpreted, so that there's some consistency both between the Inspector General and the board, but also just consistency in your review of different cases with regard to that rule. Rob obviously has been gone for some time with his family, so I had a conversation with our Labor and Employment Division, who works very closely with the folks that interpret the contract and also take care of any litigation with regard to grievances of the FOP contract, to just talk through with them some of my concerns and where I thought we should be headed with regard to interpretation of the rule. Bethany has circulated kind of a written opinion from our office with regard to how we think Central Work Rule 8 should be interpreted. I would ask that if you have your phones, can look at it as Susan kind of goes over that information. And then if you have any follow-up questions after that, we will take them. I don't anticipate this taking more than about 10 to 12 minutes. Bethany just sent it, by the way. We had some last-minute conversations, but all is well with the information that she just sent to you. So if you could take a look at it while we go over it, it'll be a good point of reference for you. And with that, I'll turn it over to Susan Williams. She is the Deputy Chief of our Labor and Employment Division here at the City Attorney's Office.
Thank you. Can everyone hear me? All right.
Could I
well,
just ask one question? Where was it sent?
I sent it to both emails.
Okay, thank you.
We're good? Thank you. My name, as Tiara has already indicated, I'm Susan Williams. I am the Chief of the Labor and Employment Section. I got a promotion. And I'm going to let Paul Bernhardt, who's my associate, introduce himself.
Good afternoon, everyone. My name is Paul Bernhardt. I am also with the Labor and Employment Section and work with Susan.
So generally, we answer all questions dealing with labor and employment issues for the City of Columbus. And when this issue came up, Tiara came to us and asked us to just go over it with you guys so there's a better understanding of how to use Central Work Rule 8. Now, the Central Work Rules are the rules that have been established by the administration that cover all appropriate and inappropriate conduct for all city employees. And Central Work Rule 8 is one of those general rules of conduct. It basically covers appropriate behavior. It covers everything from gambling to soliciting to cursing to you name it, it's all under there. If you've read it, you realize it's really a very broad rule. And it's one of those rules that pretty much anything can fit under. Now, when you look at, I want to direct your attention to what's called the rules of conduct. Division of Police, under the Department of Public Safety, they have what's called the rules of conduct. Now, these rules have been established by the division with approval by the Department of Public Safety. These specific rules, again, cover what is considered appropriate and inappropriate behavior for division personnel. Now, for those of you familiar with the Division of Police, they cover both sworn and unsworn, uniformed, and plainclothes personnel. So they fall under the rules of conduct. Also with the rules of conduct are the division directives themselves. The division directives, again, apply to all division personnel. When it comes to charging or disciplinary actions with division personnel, what you're going to find and what has been done historically based on past practice is that the rules of conduct are going to be the authoritative basis for charges of discipline, okay? And then you're also going to note, what we've noticed is that on top of that, so think of like a layer. So you have the rules of conduct, which gives you your general stuff. Then you have the division directives. Sometimes, now again, if it applies, the division directives are going to be a little bit more detailed. As you understand, the Division of Police is like a paramilitary organization. So they have everything from how to wear your hat, I don't think that's in there anymore, but stuff like everything, how to wear their uniform, what else am I, it's like every little detail is in there. That's going to be in their division directives. And sometimes on top of that, they will add the Central Work Rule 8 because it's all-encompassing. Now, what we do not want to happen is that the Central Work Rules alone, while it applies to all city employees, the authoritative rule is the rule of conduct for the Division of Police. So you don't want to just charge or recommend charges, rather, for the division just under Central Work Rule 8, okay? Now, interestingly enough, we have not found any arbitrations that deal with that specific issue. but it's been the practice of to not charge under Central Work Rule 8 alone for division personnel. Does that make sense? Now, that guidance is also, you're going to find, what makes it even more confusing is when you look at the rules of conduct themselves, I think it's 1.02 or 1.03, 1.0. Well, 1.03 talks about the rules of conduct are the most authoritative directives issued and shall be the basis of formal discipline. So that gives us our guidance there. But the rules of conduct are also reiterated in 1.02 of, I'm sorry, the City Central Work Rules are reiterated in Division Directive 1.02. So it can get kind of confusing, but you can't charge a division personnel just with Central Work Rule 8. You have to put that layer on, and it is adding on. But if you think about it, because it's all encompassing Central Work Rule 8, there is a division directive or rule of conduct 1.36, which is what's called unbecoming conduct for officers. That's their general all-encompassing. So if you're going to find someone 1.36, you should be able to find a violation under Central Work Rule 8.
And vice versa.
No, thank you for that. So kind of the question I'd have is, Civilian Review Board makes a recommendation under Central Work Rule 8, but ultimately that recommendation is sent to the police chief and the safety director. And so I guess is the suggestion here that even if we make that recommendation, or, that we shouldn't make that recommendation, I'm just trying to get a sense in terms of, because ultimately if the police chief or the safety director decided that actually this falls under an additional policy, they make that ultimate decision. So I just wasn't sure in terms of whether you're just trying to get us to be a little bit more precise when we make that initial recommendation, and just wondering if that question.
Yes, exactly. Make it more precise. If you have all the details up front, there's less work to do on the back end. So if there's if you say something, you determine if there is a recommendation that it is a violation of Central Work Rule 8, Rule of Conduct 1.36 will probably fall in line, and it is best to just go ahead and add it. And then there may be another rule of conduct that may also apply.
Gotcha.
Don't not put it in there simply because you're not sure. It's better to put it in there.
So may I ask, when we used Central Work Rule 8, it had to do with conduct that we considered to be unreasonable, but it may or may not be conduct unbecoming to an officer. And here was the concrete example, so help us to classify this correctly. We had a case involving an officer who recommended to an angry young man who was locked out of his mother's house that if it was his house, he would have kicked the door in or thrown something through the window, but no one would lock him out of his house. And so we considered that recommendation to be unreasonable. He was just pouring gasoline on an obviously overheated situation. When the officer left, the young man went into the house and broke up all of his mother's furniture and kicked in her television and so on. We were recommending that we had cited Central Work Rule 8 as the basis for our recommendation of additional training or discipline. Would you say, based upon the history of interpretation of this Rule of Conduct 1.36, that those comments or recommendation by the officer would likely fall under 1.36? We're happy to use that. Mm-hmm. It's just not obvious to me that that's appropriate.
Good question. I think just by the example, with little information I have, but just going by the example you've given me today, I would say it would could possibly fall under 1.36. When you look at 1.36, unbecoming conduct, it says division personnel shall conduct themselves at all times both on and off duty in such a manner as to reflect favorably on the division. Is this the type of behavior that acts reflects favorably on the division, I would say no. Again, it's a general provision,
We're
and I
happy to
think it's
use
all
that.
encompassing.
You know, we were looking for something that, for us, that we had several cases where the officer's behavior fell short of what we consider to be a reasonable person's standard, that there just was a utter lack of common sense. And we were, where does that fit?
I think we would recommend that anytime that you find that an officer's conduct is in violation of Central Work Rule 8, almost all the time, I can't think of any circumstance that it wouldn't also violate Rule of Conduct 1.03. And when it comes to, at the end of the day, these cases, can get challenged and go to arbitration, and we would feel much stronger, arguing at arbitration the 1.03 or 1.36 as a starting point of that's the rule of conduct that's been violated.
Right.
And then we can also make the additional arguments that Central Work Rule 8 applies as well. But, the officers are told that if they're going to be formally disciplined, it will be for violating a rule of conduct.
Okay.
And they do understand that it is, even though they're told it's going to be for violating a rule of conduct, it's also written in their directives and their rules of conduct and in their bargaining contract that they are required to follow all rules and policies of the city. So it's not just the central work rules. It also applies to the EEO policy of the city, sexual harassment, workplace violence policy. They are not just, it's everything. So when you're looking at recommending charges, look at it as a whole.
And I think the important point to that is the directives say that the rules of conduct are the most authoritative division rule and directive and shall be the basis for discipline for the officers. So if you're looking for a catch-all provision, it should come from the rules of conduct, and then you can stack on the central work rules if you'd like, but the rules of conduct are going to be your authority there.
Do that, it would just be helpful for the IGs, the investigators, to take a look at this Rule of Conduct 1.36 when it pertains to unreasonable conduct. We were citing it because that was the work rule that was cited by the IG. And so, yeah, just a recommendation.
Yeah, I'll just chime in. So I think where the problem arises is if the IG does the investigation and finds no violation of that 1.36, and then you review that and disagree with that finding. So in that, right, so that's, and then you use the Work Rule 8 as kind of the backup or the catch-up.
They didn't cite 1.36 in these particular cases, so that's why we used Work Rule 8. But we have no problem with this catch-all provision. That's great.
I just think, and if you disagree with me, let me know, but the IG should be the one doing the initial investigation to determine if there's a violation of 1.36. And then when you get her recommendation, yes, there was a violation, no, there's not, then it's for you to decide whether you agree with that or not.
Right, and in the case where it came up, Work Rule 8 was cited in a footnote.
And then we just did not agree with the final determination. In that case specifically that Rich just gave as or Board Member Nathan just gave as the example, the Work Rule 8 was cited because the investigator who did the report looked to it, but then at the end found, I can't remember if it was exonerated or unfounded, and our recommendation was, given what we went and read in Work Rule 8, because that's what was cited in the report, we disagreed and we said that the officer's conduct in that case needed additional training, that officers probably should not be adding fuel to the fire. And then the exact thing the officer said he would do is what the kid went and did. And we just thought that there should be some more training about what the weight of those words can mean in that type of situation. So we only knew about Work Rule 8 because it was cited in the report itself.
I think it's just a matter of process, like, is it better to say we disagree with the IG's finding that there's been no violation of 1.36, and we find that there is a violation of 1.36, and based on that, we're going to recommend the following, versus saying, well, okay, we understand that she found no violation, we're just going to move to work rule 8.
I kind of have a question on that. I mean, because ultimately, still, the recommendation would go to the police chief, and then she's got the entire report with it, right? The IG's found one way, CRB found another way, and ultimately, the police chief is going to be making their own recommendation. So I understand in terms of the process point, but I'm just, just trying to think through, especially when we talk about the best practices, what is the best way to move forward when we send a report so that, a decision is made that ultimately is going to be something that the police chief decides.
Well, I think I may have stressed this a long time ago, that the board, in theory, the board should be giving some weight and merit to the IG's investigation and findings, just as the chief of police should be giving some weight and merit to the findings of the board.
Are there any other questions? Well, thank you so much for coming today. I think this has been quite informative, and we'll be able to help the members of the board as they move forward, and the Inspector General's office also, I think. So thank you very much. It was good to see you. We are going to, at this point, move forward with item 4, the review of December assigned cases. Chair of the subcommittee, McIntosh.
Okay, I'll start with 22-0164.
What was the number? Oh, okay, you were adding the 22 in front of which threw
Yep.
me off.
All right. On August 15th, 22, complainant called CPD to have them check on the well-being of her now deceased sister. August 17th, she called to file a complaint alleging misconduct and neglect of duty because a wellness check for her sister allegedly was not completed by CPD. The complainant believes her sister would be alive if officers actually went out and spoke to her, because they would have seen she was not fine. The investigator for the IG viewed the body-worn camera of the officer, which in fact shows that the officer did check on the well-being of the victim on 8/15 of 22 at 1:24 p.m. The officer did enter her bedroom where she was found sleeping. She did, however, pass away later that evening at 10:16 p.m. according to CFD. I motion that the board accepts the DIG's findings of exonerated for case number 22-0164.
Second.
Questions?
Yeah, just,
Oh.
were there any concerns or comments or in that particular case that you all had? Sorry, I can't pull up the review. I'm trying to pull up the review sheet. But that just
No.
was a general question if you had any concerns or comments.
Not at all.
All in favor of the motion, please raise your hand. Approved.
Case number 22-0175. June 16th of 22, officers were dispatched to a burglary in progress, 4375 Lee Marie Place. Caller described suspect as a male wearing a white tank top. A male with a white tank top, and he was later identified. Officers asked him to stop as he started slowly walking away. Then he took off running. Both officers gave chase. One officer deployed his taser but missed. The other officer caught up with the suspect, gave verbal commands, and cuffed the suspect without incident. However, one officer did, in fact, use profanity while in pursuit of the suspect. The suspect was placed inside a cruiser. A detective approached. read him his Miranda rights, and then began to ask him questions about the burglary. On August 18th of '22, that suspect filed a complaint with the DIG alleging his first allegation, CPD did not read him his Miranda rights once he was arrested. Allegation number 2, unnecessary force was used against him during the arrest. Allegation 3, officers made false claims against him stating he was obstructing when he stated he was not. And allegation number 4, officers racially discriminated against him during this incident, since a race was not mentioned when a description was given for the initial call made to CPD. Allegation 1, and the body-worn camera shows that Mr. Robinson was, in fact, read his Miranda rights by the detective on scene. Oh, yeah. Okay. Allegation number 2, according to the investigator who reviewed the footage of both officers, she did not see or find any acts of unnecessary use of force. Allegation 3, the suspect did obstruct by running away from the officers, attempting to evade and avoid arrest. And allegation number 4, the suspect became suspicious not due to his race, but due to his behavior. So I motion this board accepts and agrees with the findings of the DIG of exoneration of all allegations, case number 22-0175.
Is there a second?
Second.
So in that particular case, it was my understanding that the investigator found that one of the officer was using profanity throughout. Is that
Yeah, and that also was recommended,
okay?
that this report be forwarded to the chief of police, safety directors.
Okay, so that's something I might, consider in terms of the broader board, if it was determined potentially that this was a violation of policy, that's either an additional addition as a sustained allegation if the investigator found that to be the case.
And in all of mines where an officer used profanity, even if there wasn't a complaint about it, they have always recommended that the report or the investigation be forwarded to the safety director and the chief of police for disciplinary actions. So in all of my cases.
So I'm a little confused.
Yeah, I am too.
In this case, did the investigator find, after reviewing body cam, that there were no incidents of the officer using profanity?
No. He did in fact use profanity. There wasn't a complaint made about the profanity. Those 4 allegations were the allegations that were made. The investigator himself or herself recommended that this report be forwarded to the chief of police and the safety director for possible disciplinary actions.
Okay, so you're saying on the charges, the officer, the complaints were unfounded, but there was an additional recommendation?
Based on the investigator.
Gotcha.
Yep. And they were all exonerated.
Okay. Well, I don't know how we do this procedurally, but I think there should be an additional allegation that we just spoke about and add it to that piece that would be sustained, so that that's there for the record in terms of for discipline policy.
Yes, Ms. Ross?
Thank you, Chair Jackson. I think that is how the procedure will change from here on. Anytime there is an additional finding of misconduct that is outside of the original allegation from the citizen, it will be a DIG-initiated allegation so that it can be sustained, so it can go through the process clearly. I think these are older cases, so we hadn't established that procedure, but that is consistent with what IAB used to do, and I think that is clean from an FOP perspective. It will keep us out of the possible red flag for grievances if we do that. So I don't know if it makes sense to just motion.
So this is how I like to proceed. Let's vote on the motion. And then I think it would be appropriate for an additional motion made specifically around profanity in this case. So there'll be 2. So on the first motion, where there's an exoneration, I believe it all for All who approve, please raise your hand. Now, the chair will entertain a motion around this use of profanity.
I would make a motion to add an additional allegation that be sustained for the violation of the misconduct for the use of profanity
I second.
in this case.
Any further questions? All in favor, please raise your hand. Motion passes. Thank you.
Let me ask you this. Had we not made that motion, would it have proceeded as it would now? They would have ignored it. You understand what I'm saying?
What do you mean?
So
Wouldn't have they-
even, so Kyle made the motion about the profanity. Had he not done that, the IG had already recommended that the case be forwarded. Would the same result had happened had he not made that motion?
I think what you're asking is, would the DIG have just forwarded it herself?
Correct.
Without the motion? I don't know the answer to that.
No, I mean, the DIG should not be forwarding anything directly to the chief of police. Her chain of command is to you all, and then you all will forward your recommendation based on her findings to the chief of police. The DIG makes no recommendation with regard to discipline. It is the board's recommendation. The DIG makes findings with regard to her investigation.
And what you'll see moving forward is the DIG will initiate a new complaint for that additional use of profanity. So you'll get it'll have two separate case numbers moving forward. Here,
No.
these are just, right, two different?
Not two separate case numbers. It'll be a part of the same case,
Just a
but it would
different-
be a DIG-initiated allegation so
Okay.
that you can sustain it.
Thank you.
And technically, you all have the power to initiate your own allegations. You've delegated said power to the IG, and I think it makes more sense process-wise, and I think Chair Jackson was alluding to this at the last meeting, for the DIG to go ahead and make that additional allegation, sustain it and/or exonerate it, and then you all can agree or disagree with that finding.
And that's what will happen in the future. As Ms. Ross said earlier, these are older cases, so we will see a change that will make this much smoother going forward.
And for today, I think that process you just did works out fine, because again, you guys pursuant to charter have the ability to motion your own allegations.
And just to remind everyone, for previous cases in which those similar things happened, we tried to be very careful in restating our motions when we needed to add the extra line in instances where there was exoneration but a recommendation for training for those. So not to make anyone think we missed any of the previous ones, we just had much wordier motions.
You're getting to the same result, it'll just be a little cleaner moving forward.
Your next case?
22-0215. On August 22nd of '22. Young man was traveling westbound on I-70 near I-71. He was stopped by an officer for a traffic infraction, was written 3 citations, one for speed, 61 into 45 construction zone, window tint, and a license tag violation. That young man filed a complaint with the DIG citing 4 allegations. First allegation, the officer singled him out since he was not the only one on the freeway and wrote an excessive amount of citations. Allegation number 2, the complainant alleged there was no construction workers present when he was stopped. Allegation number 3, the complainant alleged that the officer did not tell him he was cited for speed initially. And allegation number 4, the complainant did not like the way the officer took the license and insurance card from his hand. A review of the officer's BWC by the DIG investigator shows that allegation 1, officers have discretion as to whom they stop for a traffic violation, exonerated. Allegation number 2, BWC shows there were construction workers present, unfounded. Allegation number 3, BWC shows the officer did not on his initial approach, advised the young man of the reason he was being stopped, sustained. And allegation 4, as far as how the license and insurance cards were taken from him, from the complainant, the officer's action did not appear to be outside of CPD policies and procedures, unfounded. I motion that we, the board, accept the findings of the DIG, exoneration of allegation number 1, unfounded for allegation number 2, sustained for allegation number 3, and unfounded for allegation number 4, case number 22-0215.
Second.
Any questions? All in favor? Motion passes.
22-0304. August 31st, 22, a young lady was involved in an auto accident. The officer responded to the accident. The young lady asked the officer for the other driver's info. The officer stated that the other driver's info would be on the report. The young lady filed a complaint with the DIG alleging that the officer refused to provide her with an exchange of information/ID form. BWC footage shows that the officer was in violation of CPD policy and procedures, Division Directive 5.05 and SOP 2.02, stating that officers are to provide operators with the exchange of ID information form U20-104. So I motion that we accept the IG's findings of sustained.
Is there a second? Second. Questions? All in favor? Motion passes.
22-0333. September 20th of 22, officers responded to a DV call at the home of the mother. Upon arrival, the officer observed a physical confrontation between the sisters. One was 31 years old, the other was 16 years of age. The officer was able to get them separated and seated on the couch. Another officer arrived at the scene and asked the older of the sisters to go outside to speak with her. According to the older sister, her 16-year-old sister had taken some of her electronics without her permission. The 16-year-old used profanity throughout her interactions with the officers and refused to calm down. She also threatened her older sister. The older sister was finally asked to leave. The mother filed a complaint with the DIG citing the officers did not properly address the complainant's daughter's mental health issues. And second, the officer was rude and discourteous by stating, "This is my house now," and the use of profanity. BWC footage shows no violations of CPD policy was observed from the first officer on the scene. DIG recommends she be exonerated from allegations 1 and 2. The second officer on scene did use profanity while she was speaking with the 16-year-old. DIG recommended exoneration from allegation number 1, but allegation 2 was sustained due to her use of profanity. I motion that we accept the findings of the DIG.
Second.
Questions?
Just reiterate the case number.
22-0333. $22-0356.
Oh, I'm sorry. I distracted myself, or maybe Mr. Tobias did. All in favor of the motion, please raise your hand. Thank you.
All right. 22-0356. Easy breezy.
Is this administrative closure?
Yep.
Okay.
How'd you know?
I'm now looking at it.
Okay. Young lady filed a complaint with the DIG alleging that a CPD detective failed to properly investigate her sexual assault case. She was advised by the DIG that they do not have the authority to investigate criminal matters. I motion that we, the board, accept the DIG's recommendation that case number 22-0356 be administratively closed.
Questions?
In, just in these particular instances, when these incidents occur, is it the practice, the process, the IG's office to forward them and connect them with the resources that they, is that kind of the practice?
Yes.
Okay, thank you.
Thank you. All in favor of the motion, please raise your hand. Motion passes.
22-0364. October 2nd of 22. Complainant filed 2 police reports with CPD. In the report, she states she was assaulted and that her camper had been broken into and damaged. Some of her belongings were stolen, including her TV. There were no witnesses to the assault or burglary. The complaint states that a neighbor assaulted her and burglarized her camper. On October 3rd, she filed a complaint alleging that officers did nothing and left her to be assaulted again by the suspect. According to the DIG investigator, who reviewed both officers' body-worn cameras, officers did exactly what was required of them by CPD policy and procedures. One officer completed an assault report, the other officer a burglary report. The complainant was referred to the prosecutor's office to inquire about filing charges on the person she says is responsible. The officer also advised the suspect to stay away from her while she was gathering her things to leave the premises. The complainant was also told to stay away from her neighbor. And I motion that we, the board, accept the DIG's findings of exonerated for both officers. Case number 22-0364.
Second.
Any questions? All in favor of the motion, please raise your hand. Motion passes. We will now move to item 5, and I will turn to Pastor Nathan.
Yes. Thank you. This is case, I'm going to just do the 0362. So case number 0362, complainant alleged that the officers used excessive force, alleging that it resulted in multiple injuries. The facts of these, the investigation revealed complainant was in multiple fights throughout the evening. In each of those incidents, he sustained injuries, including being knocked out and being unconscious repeatedly. Officers arrived on the scene during one of the incidents in which the complainant was in a fight that involved multiple male adults. The officers used mace to break up the fight. This was recorded in BWC footage, and the complainant was punched in the face by an unidentified male, not the officer. After that, the complainant walked away, was shortly involved in another fight, which drew the attention of the officers. The officers attempted to detain him with a level 1 use of force, but the complainant ran. Thereafter, they caught up with him, brought him to the ground, put a knee in his back, and got him cuffed. Once cuffed, the officers stood the complainant up and took him to a squad car. The complainant told the officers that he had been knocked unconscious repeatedly throughout the evening by being involved in multiple fights. The complaint was that the officers used excessive force, and the finding of the IG was exonerated. This subcommittee agreed with the IG's recommendation, so I move to accept the IG's finding of exoneration in case number 362.
Second?
Quick question.
Could we get a second before questions? Okay, thank you. Now-
Said a quick question. Sorry, I'm still trying to pull this one up. Was there any concerns with that particular case?
None.
Okay.
No, he was repeatedly in fights throughout the evening and was repeatedly knocked unconscious. There was no evidence that the injuries that he sustained were the result of any use of force by officers. There was no way to parse out where all of his injuries came from, given his own admission that he was knocked unconscious repeatedly throughout the evening.
Got it. Thank you.
All in favor of the motion, please raise your hand. Approved.
Case number 0367, the complainant was a homeowner whose neighbor called and reported a burglary to the police after seeing someone enter his home through a second-floor window. The officers showed up with weapons drawn, brought the the occupant, who happened to be the homeowner, restrained him temporarily. Presumed burglar was actually the homeowner. Following initial contact with the officers, had his identity confirmed within about 9 minutes. The allegations are that the CPD arrived at his home with guns drawn, that they didn't try to establish his identity, and that he was treated like a criminal in his own house. The findings are, with respect to these three allegations, number one, that the CPD did arrive at the complainant's home with guns drawn, but they're exonerated. They followed their rules. That they did not try to establish his identity, that was unfounded, and that he was treated like a criminal in his own home, that was also unfounded. Therefore, the subcommittee agreed with the IG's recommendation, and we moved to accept the IG's recommendations of exoneration as to the first count and unfounded as to the last two counts.
Second.
Questions? All in favor, please raise your hand. Motion passes. Thank you.
Case number 0368, the officers were called to the home of the complainant's former live-in girlfriend. He had moved personal items from the apartment several weeks before and had returned following a truck driving job in Detroit. He asked to sleep in a bedroom. They had a difficult prior history, including protection orders against each other that had been dropped at the time of the incident. The complainant's girlfriend reported to the officers that she didn't feel safe with him entering, so the officers did not allow him to enter. The allegations are that the officers didn't activate her body-worn camera during the incident, that the officer was rude and discourteous to the complainant by yelling at him and not allowing him to remove items from the home, and that the officer informed him he could not stay in his own home. The findings are that all of these allegations were unfounded, and the subcommittee moves to agree with the findings of unfounded regarding these allegations.
Second. Any questions? All in favor of the motion, please raise your hand. Motion passes. Thank you.
Case number 0369, the complainant and the mother of his children got into an argument, which resulted in the complainant being arrested. The argument occurred when the mother came to pick up her children, who were with the complainant that day. She had a protection order against him, but during a drop-off and pickup, the two were around each other. The complainant alleged that the mother of his children punched him in the face 30 to 50 times during the argument, and that his son told responding officers the complainant shoved her only to get her off of him. The investigation reflected that a 911 call came into dispatch alleging that someone was screaming at the home. When the officers arrived, the mother of the complainant's children was hanging out of a window. She reported that she and the complainant had been drinking together and thereafter got into an argument that became physical. The son of both parties told the officers that the complainant was the aggressor. The allegations are these: that the officers wrote a false report against the complainant, which resulted in his eviction. Second, that an officer forced the complainant's son to say things that were false. And third, that the officer exhibited prejudice and discrimination against the complainant by saying, "I know your type." The IG found that with respect to all three allegations, these allegations were unfounded. The subcommittee moves to agree with the IG's recommendation regarding the finding of unfounded with respect to all three allegations.
Second.
Any questions? All in favor? Motion passes.
Case number 30379. The complainants were employees of Nationwide Children's Hospital who observed two officers interacting with the father of a gunshot victim who later died of his injuries. The officers were waiting outside the door of the victim's room. The father of the victim exited and was upset. The officers at first appeared to engage with the father, admonishing the father to not talk to them in that manner. Hospital staff, including a doctor, got involved at one point, getting physically between the father and the officers. The doctor and the staff believed the officers lacked empathy in dealing with a grieving father. So the allegation is this, that the officers behaved in an unprofessional and inappropriate manner when dealing with the father of a patient who was a gunshot wound victim at Nationwide Children's Hospital. The IG found that while the officer was stern, his conduct was not unprofessional, and as a result, the IG recommended that the officer be exonerated of the charge of misconduct. We move, the subcommittee agrees with the IG's recommendation and moves that the officer be found to be exonerated. Yes, please.
Could I get a second to the motion first?
sorry.
And then I'll entertain questions. Yes. There was a second, so now your question.
There was some sort of an allegation that the doctor had to give between the officer and the father.
Yeah.
Now, what evidence did the IG find that, did they interview anyone, or what evidence did they find to base
Let me
their?
find the original case. It appeared to the subcommittee, I'll have to look at the specifics, but Mary, it appeared to the subcommittee that we really had a different orientation regarding healthcare professionals and social workers in the way that they would approach a grieving father and the way the police officers did regarding their respective professional training, but that the officers had not done anything that was a violation of their, professional rules of conduct.
Was there
There was-
video footage or
Yes.
body-worn
Yes,
camera or any of that?
yes.
There's video footage, both from the hospital and so the gunshot victim died during the course of this happening. And so the dad came outside and was very upset, starts yelling and getting loud at the officers. The officers stand up and the medical staff get in between them and they start trying to lead the dad further away down the hall, away from the officers. The officers are still talking to the dad.
Dad was cursing at the officers. The officers said, "You can't talk to us that way." Dad continued to scream and curse at the officers, and at that point, the medical professionals stepped in.
Yeah, so very emotional dad. I think the medical professionals did not believe the officers were as empathetic as they are about what's happening, which is probably true. But there's
yeah.
I think the IG's investigators said there's no requirement for empathy. So there's nothing that we can say, like, we'd hope that people would be empathetic when
Yeah,
a kid
yeah.
is dying. And the dad, is very emotional about that, but that was
The
not.
officer's statements were things like, "Stop it, you can't talk to me that way. You need to calm down, you're making it worse." Those kinds of statements. There wasn't any
So it's-
any vulgarity or anything used.
Yeah.
There just wasn't this sort of empathetic approach that social workers might have taken regarding a very upset dad who just lost his daughter.
So there was no policy violation, but taken that this father just lost a child, maybe their concern shouldn't have been that you can't talk to me this way. Silence would have probably been preferred. I mean, they didn't do anything wrong, but,
Yeah.
So,
okay. All
let's
right.
vote on the motion.
All right.
All in favor? Jesus. Motion passes.
That was number, let's see, 379. Case number 0380. In this case, the complainant woke up about 5:30 in the morning. He heard sounds from his front yard and saw a person sitting in his truck. Assumed the truck was being stolen. He picked up his handgun, went outside to confront the thief. Person began to drive his car into reverse, and the complainant through the complainant's front yard towards the complainant, who began to shoot at the tires of his own truck. He reported that he went out inside thereafter to wait for the police. He and a neighbor called 911 to report the incident. 7 officers responded to the home. The complainant allegedly told the officers he had fired a couple of shots at the thief as well. Truck was found unoccupied. The investigation showed the complainant was upset when the officers asked him to step away from the truck, and the crime scene insisted he could go to his truck if he wanted to. Complainant used profanity and got into a verbal altercation with one officer. Complainant also argued with the medic who was on the scene, and the complainant made, I think this was ethnic, was this the one with the ethnic slurs against the officer?
I believe so.
But made insults against one of the officers, said disparaging things about the officer's mother. The evidence, the allegations are these: that the officers harassed the complainant during an incident that occurred near his home, that the officers detained the complainant and made him sit in the back of a cruiser for 2 hours, and the officer told the complainant, "We are here as a direct result of your poor decisions." So the complaint concerning the 3 allegations, the IG's findings were that these allegations were unfounded. The subcommittee moves to find that regarding all 3 allegations against these officers, that the IG's findings of unfounded be accepted.
Did you put the case number in your motion?
I did. Oh, I'm sorry, in case number 0380.
Okay. Is there a second? Okay. Questions? All in favor of the motion? Motion passes. Thank you. We're going to be in adjournment for 10 minutes. This is our break, and I know we're moving along smoothly. Pardon?
I'm going to leave a little early, but that's fine.
You'll be up first?
Yeah.
When we come back? Okay. Mr. Strickland, are you ready to proceed? I am. Please do.
So this first case is complaint 0389. This was a case where the complainant contacted Columbus Department of Inspector General alleging that an officer lied regarding an accident that the complainant was involved in, which another person hit her, recognized here as driver 2. The complainant feels that driver 2 and the officer knew each other because he would not listen to the complainant and also cited the complainant despite there being video footage of the accident. The complainant believes she was not at fault and feels both the officer and driver 2 lied. Based on the information and statements received in the body-worn camera footage and documents reviewed regarding this incident, the Columbus DIG recommends a finding of unfounded for allegations 1, 2, 3, and 4. And those allegations were that the officer lied, was allegation 1, 2, that the complainant alleged that the officer yelled at the complainant, and 3, that the officer and driver 2 knew each other because they would not listen to the complainant. And then 4, the officer cited for changing lanes despite the complainant having video footage of the accident. We had no issues with this case through our review, and so we agree with so I'd make a motion to agree with the IG's recommendations of unfounded for allegations 1, 2, 3, and 4 regarding case number 0389.
Any questions? Then all in favor of the motion, please raise your hand. Motion passes.
Next, we have case number 0390. The City of Columbus Department of Inspector General received an investigation regarding an allegation that Columbus police officers failed to properly assist a possible sick injured person located in her apartment complex. The complainant notified a 911 dispatcher of a man lying in the stairwell of her apartment complex, and she was informed a medic and officers would respond. The complainant claims that when an officer arrived to the scene, he allegedly berated the man for blocking the stairway and pressured him to get on his feet without checking in on his physical condition. The investigators reviewed the 911 audio to obtain the information and additionally reviewed the computer-aided dispatch report to determine what type of call was dispatched to cross-check the information with policies and procedures with CPD. They also reviewed the body-worn camera footage and found that officers were dispatched to the incident, but that there was no violation in this particular case. So it turns out in the specifics of this case that someone else was there to also respond with Columbus Fire, and there was no particular issues here in this situation where the allegation of the officer berating the man, of blocking the stairway and pressuring to get him on his feet, they found that as unfounded. And our subcommittee agreed with the IG's recommendation of unfounded for the allegation of berating the man. So that would be my motion.
Did you say the case number?
Case number 0390.
Okay, thank you. Any questions? All in favor, please raise your hand. Thank you.
Case number 0405. The Columbus Department of the Inspector General received a complaint of excessive use of force and the arrest of complainant. So I'm going to be using complainant here, even though this was actually filed on behalf of an individual, but for purposes of the summary, we're going to reference that individual as the complainant. So the complainant alleged that 10 TV ran a news story about the complainant trying to kidnap a police officer. The complaint alleged that the complainant's vehicle was surrounded by police officers and that an officer escalated the situation. The complaint also alleged that the complainant was snatched out of his car and was beaten by several police officers so badly that they had to call an ambulance and have him taken to the hospital before being arrested. The complaint alleged that 4 to 6 police officers were involved in throwing the complainant to the ground and beating him. The investigation indicated that a CPD officer initiated a traffic stop based on the equipment violation he witnessed, which was the tent on the complainant's vehicle being too dark. When the officer came back to the complainant's vehicle during the stop, the complainant fled in his vehicle, causing the officers to initiate a pursuit. The complainant exited his vehicle on foot a short while later and was pursued on foot by the officers. One of the officers drew his firearm after seeing that, according to the officer, that there was indication that the complainant may have a firearm, and gave commands to the complainant to stop running and to get on the ground. The investigator stated that after the officers caught up to the complainant continued to actively resist arrest until he was placed into custody by 3 CPD officers using minimal force allowed by CPD Policy 2.01, use of force. The investigation found no evidence to support the complainant's allegation of excessive force. Therefore, the investigator recommends that this is closed with the finding of unfounded. So there are a couple things here that that our subcommittee wanted to bring up and make note of, is that in this particular investigation, it was revealed that the officer has a history with the complainant, including initiating a previous traffic stop with the complainant. And so in that instance, the officer alleged that the complainant ran from him, just like would happen in this instance. It was also mentioned that the complainant was struck in his rib area with 3 knee strikes by one officer and was also struck 3 times in the, quote, face and the head. The investigator indicates that these level 4 use of force actions are permitted by policy in instances of active resistance by the subject, but we couldn't necessarily find whether the investigator indicated whether the complainant was actively resisting or not. Mentioned that the officer mentioned in his use of force report that he was actively resisting. And then after further investigation into this, the investigator mentioned that the body-worn camera footage was consistent with the officer's report. And then one of the just other concerns I want to bring up was that one of the officers drew a firearm while the complainant was running away. The officers in this report indicates that the complainant gave potential indicators of having a firearm, but the investigator did not explain whether the body-worn camera footage or evidence was consistent with the officer's use of force report as it relates to whether the complainant gave indicators of having a firearm. So that was one of our concerns that we noted. Obviously, in the future way of doing these types of things, that is one of those things that we would mention ahead of time, that was our concern, just like more detail about whether the investigator also agreed with that. And I think it says it found the footage was consistent with the officer's use of force report, but more specificity on whether or not that, how we determine whether or not somebody was given potential indicators of having a firearm and what that means. There was one officer that was found to be outside of policy because of cursing, and use of profanity. And so we would recommend that this should be considered an additional allegation that should be sustained in this particular instance. But that is, so yeah, we would like to add that onto the additional finding. Based on conversations with the Inspector General in this particular instance, there was clarification that according to the investigator, the complainant was actively resisting, which is why they believe it was consistent with use of force policies.
Do I hear a motion?
So you will here in a second. So the motion is that the subcommittee will agree with the IG's recommendation of unfounded, however, would like to add an additional allegation of sustained. You want to do these separately?
Separate,
Okay.
yeah.
The subcommittee agrees with the recommendation of unfounded for this particular instance.
Second. May I ask a question? Was there any, the fact that they had prior history, the officer and the complainant, is there any suggestion that skewed the officer's perspective, or I wasn't sure of the relevance of that?
Yeah. So I don't know, right? So this is kind of, I think, a broader question in terms of how we do these types of cases, because I don't know if there's, like, if you guys have a policy or practice in place here where if there's this additional history that goes beyond the scope of this particular, well, it's not beyond the scope, but is connected to this particular complaint, whether that's something that is looked into further. I don't know how that impacts the actual investigation itself, but it seems that that was not dispositive in this instance.
Report, there is a footnote that talks about it. When the officer, well, not officer, when the investigator was reviewing the body cam, the officer made mention that he had prior history with the person. So he had stopped the person before. So it's noted in the footnote of the report that this particular person is known to have carried a weapon. And that's why the officer was just making it known to his partner and anyone else that this person could possibly be armed.
And so, and I don't know if this is part of this situation or elsewhere, but a general kind of policy consideration around this case is that this also seems that this was a predictable potential situation that could occur. And so I was wondering necessarily why that particular officer decided to make that traffic stop, knowing that there has been this issue previously. So I think that might go beyond the scope of this particular complaint, but that is something that we did make note of. Does that?
So I think we're
Okay.
at the point of voting on the motion.
And also, just repeat the case number, too.
Yeah, and this is case number 0405.
Okay. All in favor of the initial motion? Thank you.
And we would like to also make a motion on that case, 0405, that an officer was found to be outside of policy because of profanity throughout the engagement. So we would like an additional allegation of misconduct be sustained to case 0405.
Any questions? All in favor of the motion, please raise your hand. Motion passes.
Next, we have case number 0408. This is I'm just going to go quickly here. This is an administrative closure case. So the complainant alleged that CBD officers at Grant Medical Center slammed him against the glass door in the emergency room, and that there were issues there. But the investigator reviewed this case, and Grant Medical Center is part of the Ohio Health Group, which has their own sworn law enforcement officers who wear uniforms similar in color to CPD. However, further investigation determined that this event did not involve any CPD officers and should be closed as administratively closed. And we agree with that recommendation and make a finding of administrative closure for case number 0408.
That's all in favor? Motion passes.
So this is case 0411. This is a situation where the complainant stated that she was pulled over for a traffic stop by an officer. The officer issued her a ticket for making a left turn without signaling. The complainant stated that the officer should have given her a warning and not issued her a ticket. The complainant also alleged that the officer was very rude during the traffic stop. She stated that the officer asked her if a bag of chicken bones next to her car were hers, which she believed to be an inappropriate joke. She alleged that there was no reason for a canine to come to her car and that she was humiliated when she was taken from her car and placed in the back seat of the police car. She further stated that a female officer should have come and searched her and that she was further humiliated when an officer, a male, searched her. The Columbus investigator reviewed the body-worn camera footage and determined that the officer was polite and courteous throughout the stop. The question about the chicken bone bag was directly related to the fact that she had told him she had just left Church's Chicken and was ensuring she hadn't thrown the bag out of the car. The investigator stated that the, quote, search alleged by the complainant was a pat-down and not a search. And the investigator also says that the officer retains discretion on whether or not to issue a traffic citation for the infractions witnessed. The investigator stated that this type of pat-down is allowed by CPD policy, and the response of a canine was within policy. Therefore, since the officer's actions were found to be within CPD policy, the investigator recommends that the officer be, quote, exonerated of all allegations. However, our subcommittee disagrees with the IG's recommendation, specifically as it relates to allegation 4. So I'm going to read the different allegations here. Allegation 1 was that the complainant alleged that the officer should have given her a warning for turning without a signal. Allegation 2, that the officer was rude throughout the traffic stop. And allegation 3, that the complainant alleged that the officer should not have searched her and that a female officer should have been called to search her. So those 3 allegations, they make the allegation of exonerate in that particular case. And And then there's allegation 4, which they also call for exoneration, which is that the complainant alleged that the officer calling a K-9 was misconduct as he had no reason to call one to check in her car. So that's where we disagree with the IG's recommendation there, and more specifically about why we do. In this case, it was not clear why the officer requested for a K-9 to do a check of the vehicle. It was also not indicated in this report of how long it took for the K-9 to arrive. And then it says that the trooper and the officer reported that the K-9 ultimately gave a positive indication that there were potentially something in the vehicle after the K-9 check, but the investigator could not independently determine what kind of indication was based on the body-worn camera footage. So we have a number of remaining questions here. We do not believe that the investigator adequately responded to allegation 4 regarding the K-9 policy. And so further documentation of investigative steps would be helpful to explain how we got here. And so, I know this is, obviously we're kind of changing the way that in the future this will be addressed, but we would like further review of allegation 4 and documentation of investigative steps regarding the use of the K-9.
Madam Chair? Okay.
Yes.
The report does state that the officer had probable cause to order a K-9 search.
And so I see that in the report, it's unclear what that probable cause was.
It states in there that there was a ongoing investigation.
In terms of when he pulled over the person and then
The officer was able to effect a traffic stop, and based on the probable cause he had and additional information of an ongoing investigation, he had probable cause to order a K-9. The K-9 came before the officer finished writing his ticket, and based on the policy, it was timely. So it wasn't like the officer was there for a long time before the K-9 showed up. The K-9 was ordered, the trooper showed up, the trooper used the K-9 to do an indication, indicated that there was a positive response. And so based on that, it was appropriate. And it was within policy for CPD.
So in the report itself, though, it does not give an answer to how long it took for the K-9 to arrive. So, for us to know whether or not it was timely, it's not clear in that report. And so that is where, again, in the future, I think, these are the questions where we'll submit those specific questions ahead of time. But that was one of our concerns that we had. We just had, further questions regarding this case, and so not necessarily comfortable to move ahead on this particular case because of the questions.
It says here, it says, when Officer Pollard got into his vehicle, he requested a K-9 to do a check. So he went into the vehicle to write the ticket and immediately requested a check, a K-9, without indicating as to why. We didn't know why he wanted the K-9 at that particular time. What probable cause did he have to want a K-9? So then the K-9 came quickly, but then he tested, he got a positive indication, which was an error because there were no drugs in the car. But
Well, yeah, and I think I think what is being indicated is that when he made the traffic stop and maybe obtained further information, that was when he requested the K-9 because there was an ongoing narcotics investigation. However, the way that is written, at least the way I read it in the particular report, it was not clear to me as how that was determined. And so, and there were several facts that were not included in the report itself, like how long it took the K-9 to arrive, and why and now we get a little bit to why the officer requested that K-9 check. But again, there was an allegation here that the K-9 did not prolong this, or there was a mention here that the K-9 didn't prolong the stop because the officer was still writing a ticket. So again, but we don't know how long that stop was, whether or not, did did the officer pull over the person because of the not using a turn signal, or did they pull over the person because they saw plates that matched an ongoing narcotics investigation? We don't know that from this report itself, and so that's where we just have further review of documentation, investigative steps on this particular report. That would be our motion.
The other point of procedure is, it sounds like you're not going to disagree with the
The first three.
recommendation, no, for number 4, you're not going to disagree with the recommendation, it's that you need more information before you make a final decision as to allegation number 4. So, maybe you vote on the first 3, but then on the 4th one, you refer it back to the IG for more details before you make a final determination on that count.
Yeah, so we would like to do that. So we would like to move forward and agree with the IG's recommendations of exonerated for allegations 1, 2, and 3. And then we would also like to, separately, or just, I don't know how we're going to, okay, for case number 0411.
Any further questions? All in favor of the motion?
And then on case number 0411, we would like to refer back refer case 0411 back to the IG specifically for further review of allegation 4 on this case.
All in favor? Let's treat it as tabling it until next week's meeting.
Perfect.
I mean,
Yeah.
to the IG. This will be tabled until next week's meeting.
Great.
And we would expect those clarifications at that meeting. Okay?
Thank you. We're done with our cases. Thanks.
Just ask the chair or somebody else the question. That is, did we need a motion to refer this back for investigation?
I think that was the motion.
Yeah, I think the motion was referred back to.
I know that he
Yeah.
didn't, I'm just asking procedurally, was that necessary, or?
You want to make some sort of a finding on the allegation since you're treating it differently than the other 3.
Okay.
Got it. So, and then I think the way that this is set up, with the IG's recommendations, that will help address those types of things. Thank you.
Well, I mean, you're referencing the IG's recommendations, which I said we weren't going to really talk about. It's still a tight timeframe.
Yes.
Because initially, I think the IG wanted 2 weeks or something. It's still tight, which really, again, reemphasizes how the committees need to meet quickly.
Yeah.
Okay? Mr. McIntosh?
Case number 22-0417. Officers were dispatched to an AT&T mobile store on a report of a theft. An employee's notepad had been stolen. He was able to ping the location of his property on Oak Lawn Avenue. The officer and the victim went to that location. The officer spoke with the resident. The resident handed the officer the notepad that belonged to the AT&T employee. The officers asked for the resident's ID. He stated he did not have any ID and closed the front door. The victim ID'd the resident as the man who was in the AT&T store earlier that day. Officers learned that the resident's name that he had given was actually a different name and wrote him a summons to appear in court for falsification. The victim was given the report number and told to go to the prosecutor's office to file charges. The daughter filed a complaint with the IG alleging that the officers did not handle the situation with her father on October 22nd of 22 properly. The complainant believed it was wrong for the officers to issue a citation to her dad for falsification because the officers believed that he gave them false information. I motion to accept the IG's findings of unfounded, case number 22-0417.
Is there a second?
I'm sorry, I'm just trying to, what was the basis for?
The resident gave a false name. Officers learned that of his real identity and wrote him a summons for falsification.
And so the unfounded claim was that there was no evidence of,
So the unfounded goes to the allegation
that this,
that the officers did not handle the situation with her father properly, which they did. And the complainant also believed that it was wrong for the officers to issue a citation.
okay. Perhaps we can get into this another time. I'm just confused about exonerated versus unfounded with some of these claims. So we can vote on this, but I just don't know why they weren't exonerated.
And to be honest, I'll agree either way.
I'm just trying, I was just trying to follow the thread of the thought, and
What was the recommendation from the IG? I'm actually looking towards Ms.
And also,
Hendricks for
let me
that.
mention this too, the IG made 3 unsuccessful attempts to contact the person who they had written a summons for further information, and they were unable to get a hold of that person.
Let's have this conversation at
Yes.
Okay.
another point, okay?
I'm sorry, ma'am.
Was there a motion?
Yes, and
Yeah, he
a
moved.
second.
And a second. All in favor? Motion passes.
22-0424, on October 25th of '22, young lady contacted police to meet her at her ex-husband's home to get custody of their daughter per court-ordered documents. The ex-husband was shown the documents and was asked where the daughter was. After denying twice, after denying that the daughter was not there, after denying that the daughter was there, one of the officers saw the daughter in the doorway. The ex-husband was taken into custody for interference with custody. The ex-wife was granted custody of their daughter, and the ex-husband was released. The ex-husband filed a complaint alleging that the officers came to his home and placed him in custody, twisting his arm, even though he told them to stop because he had just had surgery. And he alleged that this agitated an already injured muscle and fractured bone. And allegation number 2, he alleged that officers came to his home, they had fraudulent paperwork to take his daughter from him, and that the officers did not confirm the paperwork before coming to take his daughter. A review of medical documents provided by Mr. Mitchell, the ex-husband, showed images of the shoulder surgery. He was not able to provide documentation to prove that the encounter with the officers re-injured his shoulder. The officer did call Franklin County Courts to confirm the paperwork they had. And officers turned the child over to the mother per the paperwork and released Mr. Mitchell. My motion is to agree with the IG's findings. Allegation 1, unfounded, and allegation 2, exonerated.
Second.
Brooke, did we not have this identical case?
The number is the same. I wondered that same thing.
We have the identical facts.
Yeah, we do, and I thought it was for items that they were taking, and now I'm wondering if it got bifurcated into two different reports.
We have the identical facts in another case.
That, case.
The number is the same. Yeah, I believe it's 424 as well.
Is someone checking something about numbers?
Yeah, I'm checking.
Yes, it's 424. I have it right here.
Did you read it today?
We went over it yesterday.
No, yesterday. That's what I said, this is deja vu.
So you have your February case assignment?
Okay.
Yeah.
I can look into that.
Well, I mean, yeah, I have my.
It's
Yeah.
fine, we can vote on it here. I just, we
Yeah, I
handled
did the work.
exactly the same case.
I
was just
think it
confused.
would be better if this matter be tabled until next week, since we're meeting so quickly, and that the IG's office reconcile this matter.
Yes.
Okay?
Okay.
I don't think we need a vote on that.
Okay. 22-0431. Okay. Based on BWC footage, officers made a lawful traffic stop on a young man for illegal window tint. The young man was giving his girlfriend a jump. However, in doing so, he was illegally parked. The officer legally impounded his car. The girlfriend filed a complaint with the DIG alleging 2 complaints. That the one officer inappropriately towed and searched her children's father's car while he was parked attempting to jump her car. And the complainant alleged that the officer behaved rude and sarcastically. Allegation number 1, I recommend that we accept the IG's findings of exonerated. And allegation number 2, based on that body cam footage, the officer was found to behave rude and sarcastically. So the findings on allegation number 2 is sustained. And I motion that we agree with both of those findings.
In the case number,
Case number 0431.
is there a second?
Second.
Any questions, concerns? All in favor?
I have just a quick question. What do they recommend? They sustained that the officer, did I understand this correctly? They sustained that the officer was rude and sarcastic?
Mm-hmm.
And did they make a recommendation?
Uh-huh.
What was the recommendation?
They sustained that allegation.
And did they make any recommendations?
Let me look, Mary. Yes, they wanted it forwarded to the chief's office and safety director's office for review and consideration of disciplinary action.
Okay.
But we're going to change how we do that, I think.
Yeah. Okay. All right. Thank you.
Chair Jackson, if I may,
Yes.
I believe there was an additional finding in this report that the board would need to create a separate allegation. It wasn't included in the complainants, in the citizen complaint. So there were two allegations the citizen complained about, and then there was an additional finding of misconduct with regard to the officer not providing his badge name when he was asked. So you need to do a board-initiated allegation and then sustain that if you agree.
So a separate motion for that allegation? And so you want me to motion for that
Yes.
separate
Yes.
allegation for the violation of not giving his badge number, name and badge number, in violation of rules of conduct, probably 1.36 or something to that?
As you are reviewing the IG's report and recommendation, if they've identified an additional potential violation that was not originally articulated by the complainant, if you've reviewed that and are going to make some finding on it, then I think for now, since these are the old complaints, we're just separating them in terms of the motion. So now that you've done the first two findings, you can just articulate very briefly that, during the course of the investigation, an additional violation was founded by the IG, and we want to make a motion and talk about what the violation is and whether it's substantiated or unfounded or.
And in fact, in that, let me just say this too, in the report, the officer did in fact give his name and badge number. In fact, I think he did it several times. I don't think he did it once when the male half asked for it. He had previously given it, but in one situation, he didn't give it, stating that he had given it. So, but there's no number as to how many times an officer has to give his name and badge number. That's why I think the IG recommended.
The IG recommended that there was a violation of
Yes.
policy. Right, and so that's up, as your committee was discussing it, whether you agree with the IG's recommendation or not. If you found that the other times that it was provided was sufficient, and you want to find in opposition to the IG's recommendation, that's within your authority to do so. But again, technically, there was a violation. That's why there was a recommendation to supporting that.
Okay.
I move to sustain the IG's recommendation.
Well, I would just articulate it a little bit more, that it's it wasn't a complainant, violation, that it was initiated by the IG, and indicate that based on the committee's review, what your motion will be.
Based on our committee's review of case 0431, I motion that we sustain the IG separate finding of protocol when showing a badge and refer it to the chief.
Needs to be seconded.
Is there a second? Any further discussion? All in favor, please raise your hand. Thank you.
(22-0452). The complainant called CPD on two separate occasions, both for domestic disputes with her partner. Different officers responded to both calls for service. The complainant filed complaints with the IG alleging that one particular officer made rude, insensitive, and sarcastic comments, as well as laughing with the suspect, her partner, of the domestic dispute. However, BWC footage reveals that that officer was not one of the officers that responded to the first call for service, nor was there any rude, insensitive, or sarcastic comments made to the complainant by any of the responding officers. BWC footage of the second call reveals that the officer asked the complainant, "Why do you invite him back over?" The complainant views these comments as insensitive and victim blaming. The investigator realizes that the officer is very familiar with the situation, but due to his tone not being aggressive or callous, does not believe asking her why she invites him back over rises to the level of rude or insensitive behavior. I motion for the board to accept the IG's findings of unfounded for allegation 1 and exonerated for allegation number 2.
Second.
Any questions, concerns? All in favor of the motion, please raise your hand. Thank you. And I believe that's your last case. Mr. McIntosh?
Got one more.
Oh, one more, okay.
22-0475.
Okay.
The complainant filed 2 complaints with the IG on behalf of her son. She was not present during the alleged incident. The complainant alleged that her son had his hands up to be placed in handcuffs by 2 CPD officers, and a 3rd CPD officer came out of nowhere and tackled him to the ground. Allegation number 2, the complainant alleged that after being tackled, her son was then beaten up by all of the officers. Based on the review of the BWC footage, the son, after answering a few questions from the officer, fled. I'm sorry, the suspect, after answering questions about the stolen vehicle, fled. The officers gave chase, grabbed a hold of the suspect's jacket, and placed him on the ground, cuffed him in compliance with CPD policy and procedures. The suspect complained of arm pain, for which a medic was requested. The video does not show, the BWC video does not show him raise his hands, and out of nowhere, a CPD officer tackled him, nor did it show him being beat up by all of the officers. It is recommended that the allegation 1 be closed with the finding of exonerated, and allegation 2 be closed with the finding of unfounded. Case number 22-0475.
Second.
Any questions? All those in favor? Motion passes. Thank you all for your presentations today. The March meeting, which is next Tuesday, the only thing that I have identified as carrying over would be the social media policy. Now, does each committee still have cases to present? You have the February? Okay. And can you tell me approximately how many cases do you have?
8, I think.
8 each? Okay. To the board, are there any other topics? Again, this is only, a week from now, but is there anything else that you would like to see on the agenda? You're not going to be here.
I think the one issue that came up during our case reviews was around the question of exonerated versus unfounded. We've seen a couple, and I don't know if it's investigator specific, but sometimes one term is used when it seems inconsistent with what the definition is. And so just getting some clarity, our understanding is unfounded means allegation didn't happen at all, versus exonerated means actions happen, but it does not violate policy. And so we'd like some clarity around that.
Could we get some clarity at our meeting next week?
Yes.
Anything else? Ms. Younger, I hope by next week you can begin to make some headway on that community engagement meeting. I mean, not that we will have had it, but maybe we can identify date, time, and place.
Absolutely.
Okay.
Yeah, yeah.
Has anything been referred to rules and regulations?
We are going to have a meeting scheduled to look at the discipline policy, which we're supposed to report out in April.
Okay. Anything else? Then, The chair would entertain a motion to adjourn. Yes?
One quick issue, I've missed a previous meeting, so maybe it was discussed. Appointments, I know that you were staying on top of that in terms of finding out which members wanted to remain on the board.
At a meeting, I shared that the process, and I gave her name and contact information, Ms. Rena Shank,
Shaq, yep.
right? That members are to share with her, and it said by March 1, which of
Okay.
course is tomorrow,
yeah.
their intention. Now, when it comes to a process beyond that, I'll reach out to her. The last time I spoke with her, I would say she was unaware what the process was going to be, although it was shared with me from Ms. Bishotti that she's now in charge of this. I'm not sure what's
Okay.
going to happen.
I don't remember whether, I know it's 6 and 5. I don't remember whether the 6 are up or the 5 are up.
The 5.
5. So just want to make sure that we don't get to the end of March and that hasn't been properly
Oh,
addressed. So
no.
just
Well,
want-
I mean, I can, again, check in on the 7th.
I just wanted to raise
But I
it.
don't, and I can, certainly, check, with her. But the terms are till April the 30th.
Right.
Okay?
Yeah.
Okay. Anything else? I had a motion and a second. Did we vote on it? To adjourn? All in favor? We are adjourned. Thank you.